5DZ. Mr. Clark is here today after failing to appear before referee Cruteau on June 15th, 2023. Bond is currently set at $710. This is the fifth bench warrant. He reports no employment, and there have been no payments made on this account. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 6th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Clark, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on December 6th, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No.
Okay. Well, I do note that it is your fifth bench warrant and you have a sizable arrearage and you haven't made payments at all. I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
No, I don't. Thank you.
Thank you, sir. You're free to go. Have a good day.
Encouraging too.
Hello.
Now before you is Tyrone Estelle. In each of these matters, Mr. Estelle is here today after failing to appear before this court on October 18th, 2023. For the record, those were bench warrant hearings. Mr. Estelle was previously before the court for a bond review hearing on October 9th of 2023.
Right.
He was given $50 bonds in each case, which he posted and then failed to appear for the hearing.
Right.
In the first case, bond is currently set at $532. This is the sixth bench warrant. In the second case, bond is currently $670, and this is the fifth bench warrant.
Right. A quick question.
He reports no employment. Last payment made on these accounts was on November 9th of 2023. That was the $50 bond forfeitures. Front of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on December 6th, 2023 at 8:45 a.m. before this court.
Okay.
Now look, I'd rather appear in person, sir. The only reason I missed that last time at the meeting you got left court because my phone would work for that Zoom. I would have never missed that court date, sir. And that's the only reason I got this bench warrant.
Okay. You said you never would have, but you did. I mean,
and I try to call after that, sir. Yes, I try to call and make arrangements after that. I'm not no bad person for missing child support. I try to make a what's called, sir. Okay. I mean, you got court coming up soon for my other two kids, Jaden and April 8th for the bonds or whatever for that. If you just can let me out, man, I won't miss. I'll be able to come to Battle Creek and make my court days. I just can't. I don't have no job. I'm looking for employment. I got a pregnant girlfriend out there. The police came and picked us up yesterday in front of her, and I got a car note that's due. I just got to get out so I can get back to doing everything I was doing, man. If you just can take my bonds off.
Well, the court, you're before the court charged again with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing again is to set a bond that would assure your attendance at the next hearing on December 6th, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I barely was able to post a 50 one last week. That's what I'm saying. So if you give me a PR bond, man, I'll make sure I'm here for my next court date.
Sir, when you don't show up to a hearing, you're never going to get a PR bond. So you can ask all you want, but it's not going to happen.
Okay. Well, I just paid $50 last time, so I don't have no money to pay.
I understand, and I said it for you at that time to give you an opportunity and to give you basically a
chance. Well, I know.
Yeah,
Kurt,
chance.
Okay. That's the only reason I missed though, Kurt, because I had a Zoom. I couldn't get on my phone in time, man.
Yeah.
I'm not a bad person. You gotta worry about me missing court again. All right.
Well, I thought that's what we said last time. But what I'm going to do is I'm going to set your bonds in this matter. In each case, I'm going to set them in the amount of $200. And if you're able to post that, you'd be able to be released. Do you have any questions?
Can you at least make them both 50 again? So I can at least try to make.
Not going to happen, sir.
Can you make them at least 100 apiece?
Nope. Set it
Come on,
to
you-
two
I'm not-
hundred. We were not able to motivate you at $50, so hopefully at 200.
I just missed the Zoom. Okay, well, I'm gonna send the jail to the
Sir,
6th
you're free to
then. That's
go.
what you gonna
Have a
do.
good day.
So I gotta pay 400.
Yes.
You make them at least 300 altogether, man. I don't got no job. How can I post something? I don't have a job.
Sir, I'm not bargaining with you. I set the bonds at a reasonable amount. That's what they're gonna be. You're free to
Man, that's
go.
not reasonable for a person without a job.
Sir, you're excused. Leave.
Okay, so on the 6th, I'm gonna
Leave,
stick to the
sir.
6th. If you let me on the 6th, I'm not paying no bond. I'll just be serious sitting.
Okay. Jesus, mute him. Giving you entertainment, Mr. Chapman.
That's good stuff right there. I paid 50 last time and didn't show up. Will you let me out for free this time?
Yeah.
I'll be there.
Yeah.
Yes.
Yeah, that's what he
Ms.
said
Barris
last time.
is here today after failing to
unmuted.
appear before this court on September 13th, 2023. Bond is currently set at $517. This is the second bench warrant. She reports no employment. Last payment made on this account was in July of 2023. And for the record, that was a bench warrant or a bond forfeiture, $200 bond forfeiture. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 6th, 2023 at 8:45 a.m. before this court.
Thank you. Ms. Barris, you're before the court charged with civil contempt of court duty or failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenant that the next hearing on December 6th, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, ma'am?
No.
Okay. Well, it's your second bench warrant, and court notes that again, you didn't appear at court previously. So what I'm going to do, I am going to reduce your bond in hopes that you could be released pending hearing. What I'm going to do is set your bond in the amount of $250. If you're able to post that, you'd be able to be released. Do you have any questions?
I am working with Ashley through Summit Point,
Okay.
and they're also trying to get me into Bear River, I think it is.
Okay. Well, that's fine, and hopefully they do. But that's what the bond's going to be, is $250 if you're able to post that. Otherwise, you'll remain there until our hearing on December 6th.
Okay.
You're free to go. Have a good day, ma'am.
Mr. Root is here today after failing to appear before referee Snyder on August 8th, 2023. Bond is currently set at $964. This is the first bench warrant. He reports no employment and there have been no payments made on this account. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on December 6th, 2023 at 8:00 a.m. before this court.
Mr. Root, you're before the court charged with civil contempt of court duty or failure to appear at a prior hearing as a result of
No
your
access to the
paid
Zoom,
child
sir.
support. The purpose of
I
this
had
hearing,
no access.
sir, you're going to
to-
have an opportunity to speak. Don't interrupt me.
Sorry, I thought you'd pause. Sorry. I moved it.
The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on December 6, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not able to post any bond.
Okay. And you were going to say something. What did you want to say, sir?
Oh, I'm sorry. I actually thought when you mentioned that about the failure to appear, I was about ready to get speak up there. I thought you was going to let me. I didn't mean to cut you off.
No.
I heard what else you said though about December 6th and reappearing and
Okay.
everything.
Well, what do you have to say now about not appearing?
I wasn't able to obtain the Zoom video. I wasn't able to get on Zoom. I missed the appearance. I got no contact. And the first court hearing I had with the referee in the matter, he really didn't even believe me that I wasn't working. Because the fact is, the amount that's set at $150 per a child is not even obtainable because I was not working. I didn't have a job in February, and I really need a lawyer.
Okay.
I really need a public
What happens,
defender.
sir, is they don't set your support based on what your income is. If you're not working, they will set it based upon your
He
ability.
didn't believe me. He had it on record that I was still working at AC Foundry, sir. I'm
Okay.
really not trying to be.
Well,
I'm actually pleading seriously, honestly to you. If I
Okay,
had
well,
to defend it,
what he could have done is he could have set it based upon the income you made at the foundry, not necessarily that you were still working there. So, for instance, if a person is working and they quit or leave that employment, they will impute income to them at that particular amount. I don't know because I wasn't there, so I don't know what he said.
hopefully me being here will now show proof that there ain't an employment. There hasn't been an employment the entire time, and there never was at the time of
Okay,
the case.
and again, that's irrelevant if you have
hopefully they can change the amount though by the time I'm out of here. Hopefully they can adjust it to something reasonable.
Well, what you're going to have to do, you'll have to
Sir,
file a motion to have that happen. Okay.
Well, okay. Aside from the amount or the case, the reason I wasn't able to make that was because I wasn't able to get on Zoom. Not to make a bunch of excuses, but I wasn't able to get on Zoom that day. I missed the hearing. They didn't really want to hear about it down here. It's like nobody cared to hear a word about it, that I couldn't make it on Zoom for the hearing. Nobody wants to adjust anything based on your income. I've been having a hard lot trying to get permanent work, sir. It really has been a stress. I turned my own self in to the department to settle this matter. If I had to do the time for something that, it's just like and I haven't even seen that since everything. Haven't seen them, heard nothing. I get it. And I get.
Well, what I'm going to do,
I couldn't make the Zoom because I couldn't make it on Zoom, and I know I got a failure to appear on me, and probably a large amount of child support time. Because I can't get that amount done, and I'm having a hard time with work, so I'm here turning myself into you.
This is your first bench warrant, so the court's taking that into consideration. But the court does note that you have not made any payments on this, so that's being taken into consideration. I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
Yeah, I'm not able to post a $200 bond. How long am I here?
You'll be there until the hearing on the 6th, and then we'll address everything at that time.
So I could be here until the 6th, and then after the 6th, what are we addressing?
Well, at that particular point, you're basically charged with contempt of court for failure to pay child support. You could spend up to 45 days in jail after that. I don't know what it'll be. It'll be dependent on the facts and circumstances at that time.
Because I haven't been able to even keep myself sustained and alive daily.
Okay.
So.
Well, that's all we're going to do today, sir. You're excused. You have a good day.
Yep. Thank you, sir.
And I have a few bench warrants for the record, if I may.
Mr. Chapman, what'd you do? Did you just go down there and work these people all up today?
Wow.
23 at 8:49 a.m.
Go ahead. Okay. Good morning. This matter is before the court on the plaintiff's motion for entry of a default judgment of divorce. I don't know. Do we have the? I'm on a different screen. Is Mr. Bailey present?
Yes, he's
okay.
there. Yes.
Okay. Mr. Bailey, do you have any dispute or issues with the proposed judgment of divorce?
Only one.
Okay.
I feel that she shouldn't claim the children on taxes. That's the only problem I have with it.
Okay. Does she have custody of the kids?
No.
Okay. Who has custody?
I have our youngest daughter, and her parents have our son.
Okay. Ms. Bailey, what's your response to that?
I agree with him.
Okay. Then what's going to happen is if that's the case, you're going to have to change the proposed judgment. Because I'm not going to, again, if there's that dispute and you're all in agreement, I'm not going to enter it as it's provided. You're going to have to change that judgment and then submit it to Mr. Bailey and see if he'll approve it. And if he'll approve it, then we can get it entered at that time. Or if he doesn't approve it, you can notice it back up as you did this one. Okay?
Okay.
Ma'am, what we're going to do, though, today is I am going to need to take some proofs in this matter. Ma'am, in this matter, you filed a complaint for divorce, seeking a divorce in this case. And prior to filing that complaint, had you resided in the county of Calhoun and the state of Michigan for more than 180 days?
Yes, I am. And yes, I have.
Okay. And were all of the allegations true at the time that you filed the complaint, and are they true now?
Yes.
Are you currently pregnant, ma'am?
No.
You state that there has been a breakdown of the marital relationship to the extent the object of matrimony have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. Is that a correct statement?
Sorry. Yes, it is.
Is there any chance if we didn't enter a judgment that you would reconcile and live together as husband and wife?
No.
Okay, thank you. The court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. What we'll do is simply preserve the proofs at this time, pending the new judgment and the new approval from the front of the court. So, ma'am, just make that change, those changes, and submit it to the front of the court. And once they approve it, we'll be able to get the matter concluded.
Okay. Thank you very much.
Okay. At that time, you'll be divorced. You're not divorced until I actually sign the judgment. So,
okay. You're
free to go today. Have a good day, and hope everything works out for both of you.
Thank you. You have a good day too.
At 8:53 a.m.
Have a good one.
Good morning to both of you.
Good morning.
Court will note this matter is before the court for a status conference in which we're attempting to determine where you're at in the case. And I guess I'll go with you, Ms. Herman. You can enlighten me what's happening in your case.
I would say as of right now, we have completed all the paperwork. It's just a matter of time of what you think. We are more than willing to get this process, but more than willing to wait as well. Jonathan and I are on very good terms when it comes to the case.
Okay, has Mr. Walker, has he approved the judgment in this matter?
Yes.
Yes, sir.
Okay.
Yes, Your Honor.
Okay. So we don't have any disputes in that regard.
No, Your Honor. We do, if I may, we
Yep.
do have a upcoming hearing with your referee on the 19th. So Ms. Herman and I talked, and we came to the conclusion that we want to exempt from FOC.
Okay.
So we on the 19th of December we'll be meeting to go through that process.
Okay. Is either party receiving any public assistance on behalf of the child or children?
No, Your Honor.
Okay.
No.
Ms. Herman, I didn't, was that a no?
No, Your Honor, I'm sorry.
Okay. Okay. What I'm going to do is, obviously, it looks like we just have to wait for the front of the court approval. I don't know. So what I'll do is, Ms. Herman, I'm going to take some testimony from you because we're going to have to do that before we conclude the case. So I'll take it from you now, then I'll save you from having to come back before me. Ms. Herman, in this matter, you filed a complaint for divorce, seeking a divorce from the defendant. And prior to filing that complaint, had you resided in the county of Calhoun and the state of Michigan for more than 180 days immediately preceding the filing of the complaint?
Yes, Your Honor.
And you had stated in the various things in the complaint Were all the statements contained in the complaint true at the time you filed them, and are they true today?
Yes, Your Honor.
Are you currently pregnant, ma'am?
No, Your Honor.
You stated in the complaint that there has been a breakdown of the marital relationship to the extent the objects of matrimony have been destroyed, and there remains no reasonable likelihood the marriage can be preserved. Is that a correct statement?
That is correct.
Is there any chance that you and the defendant could reconcile and live together as husband and wife?
No, Your Honor.
Okay, thank you. The court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. Ma'am, once you get that paperwork in, you get the approval from the front of the court. Whenever you submitted it, usually you take about 2 weeks, maybe 3 based upon how busy they are. But once we get that approval, we'll be able to conclude the matter at that point. When you meet with the referee, he's going to make sure that you do a opt-out, basically advice of rights, and then an opt-out order, and then you can opt out of the front of the court. I'll let you know in this matter that if you should opt out in this particular case, that is not final. At any point in the future, should you desire that you wanted the front of the court to collect it, the support, that you have a right to petition the court to have effectively opt back in. You understand that?
Yes, sir.
Okay. Any other question, Ms. Herman?
No, sir.
Mr. Walker?
No, Your Honor.
Okay. Thank you. We'll conclude this matter today at 8:58 a.m. You're free to go. Have a good day. Okay.
Thank you.
Good morning, Miss Mallory.
Hello.
Have you had any contact with Mr. Glover about this hearing?
His mom informed him of the hearing, but as of me, no.
Okay. Well, what we're going to do, I don't know. Mr. Flores, did Mr. Glover, I don't have the file in front of me. Did he file an answer in this matter?
Let me double check. He should have, because we have the, he must, I will double check. Yes, he did, and he also did a counterclaim.
Okay. Okay, ma'am, let me know, is there a dispute, or is there some?
It's not really. I'm gonna just explain the reasoning behind it. He does not absolutely do anything for my son. I've had him, like, from the time that he was born till now, I have gotten no help. He has bought 4 outfits for newborn sizes, and my son is in 6 to 9 months now.
Ma'am, I don't need all of that. I'm just trying to see if there's a dispute in the case. Is he fighting custody, parenting time, support, any of those issues?
He put in a return, like, for split custody, but he never showed up. So
okay. Well, what I'm going to do in this matter, because he's not here today, he's required to be here, so he hasn't shown, I will let you proceed, ma'am, with a default in this case that you can submit to the clerk's office, a default, and then a judgment for custody, parenting time, and support, and submit that as a default judgment. Okay?
Okay.
That way we can get the matter moving forward, because I don't know if he's going to show or not show at any point. Quite frankly, we just don't know.
Okay. Is that like something I would have to fill out, or?
Yes. Yep. I don't know if you've used a service when you were preparing your complaint and all of that, such as MichiganLegalHelp.org.
Mm-hmm.
If you are using like Michigan Legal Help, then what happens is I'll have you at that particular point, if you go to that site, they will help you prepare a judgment. They have all the forms. You'll need a judgment, a final judgment. You'll need to do a default, and you'll need a uniform child support order and a judgment information form. So you'll need those 4 documents.
Okay.
And And then what happens is you can submit, once you have those prepared, you'll have to forward them to him, but then you also have to submit them to the front of the court for their approval.
Okay.
And once that happens, then we'll be able to get the matter concluded.
Okay.
Okay, any questions?
Not right now, no.
Okay, well, thank you. We'll conclude this hearing. You're free to go. Have a good day.
9:07
Okay,
a.m.
thank you.
Defendant
You
is
too.
not here.
Ms. Mendez, good morning to you.
Good morning, sir.
This is set for a status conference so that we can see that the case is progressing as we proceed. Tell me what's happening in your case.
Currently, Israel has told me that his job was not allowing him to put her on his insurance until January 1st. He did tell me that she was priorly on insurance. But I found out that was false when I went to take her to the doctors and pick up a prescription. There was no insurance.
Okay.
So he then spoke to his job. They told him that she couldn't get on there to January 1st. So I didn't turn off the Medicaid because I can't just leave her with no coverage. You know what I mean?
No, that's fine. And probably he probably has an open enrollment period where that's the only time he can get her on. But
Correct.
you're going to have to make sure that he stays on that and then he gets it done. So.
Correct.
How are you set with the paperwork that you have to do to complete the case?
We didn't fully submit it because we were going to ask for an extension just because of the insurance purposes. A couple months ago when I did try to submit the paperwork, I'm not sure the lady, I don't know if I was doing it incorrect or if the lady was doing it incorrect. Maybe I was doing it incorrect because she was telling me it was too early to file it. And I didn't understand that.
Okay. Well, probably to complete it, but you can get them filed at any time. So, what happens is, and I don't know what you filed, so I don't know, but you can get, in this case, you can get your judgment of divorce, uniform child support order, and your judgment information form, those 3 documents, and you can submit those to the front of the court for approval at this point. And once they approve it, we just have a matter of a few days to complete the case. Then we'll be able to complete it.
Okay, because it just sucks because I submitted those papers before a couple times, but I guess because he didn't agree with it, they had to get
if he doesn't agree, he's going to have to do something not to agree. So he'll have to come in and he'll have to again dispute. He'll have to dispute the case. He'll have to file an answer, a motion to set aside default if he's been defaulted. I don't know exactly everything that you file, but you can submit it to the front of the court and get their approval at this particular point.
Okay, so could I get the name of the paperwork again? Because I called and they only gave me 2 different ones.
Okay, a judgment of divorce.
1 second, my pen is not working. See, I did this last time. Judgment of divorce.
Yep. Uniform child support order.
So if we're not doing child support, do I have to fill it out?
If you are on, that's probably, if you're on public assistance, which you are at the current time, support is going to be required. You cannot fail to pay child support when there's public assistance.
Right, because of the Medicaid.
Yes.
Okay.
So he would have to pay, and then at that point, then once she was off Medicaid, then you'd be able to then deviate and not have him pay support. But I guess this way, he's not here today, and that could be the motivation to get him to cooperate. Is he's going to end up paying support if he doesn't cooperate and sign papers or agree with you or do something at least.
Okay. So I need the judgment of divorce, uniform child support order. And is there any other sheets I need?
Yep. Judgment information form.
Okay. Yeah, because my job doesn't offer healthcare. Okay. So where do we go from here? I just turn them out, or does it get postponed? Or how does this work today?
Wait, I think, Judge, are you still there? We're ready for your hearing, sir.
Okay. Mr. Casey, in this matter, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes, sir, I do. I take full responsibility.
Okay. Well, court will let you know that you have a right to an attorney, and the court would appoint an attorney to represent you should you require or request an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes, sir, Your Honor.
Are you doing so freely and voluntarily?
I am, sir.
Has anyone threatened you, coerced you, used any undue influence,
No, sir, Your
pressure,
Honor.
or promises to get you to appear without an attorney?
No, sir, Your Honor.
Okay. Court will find that Mr. Casey does freely and voluntarily waive his right to an attorney.
He is before the court for a bench warrant hearing. He failed to appear on June 9th of 23 for a show cause hearing before referee Bradfield. This is an arrears only case. Mr. Casey is ordered to pay $78.50 per month. His last payment was July 2nd of 2021. That was $36.10 through an income withholding with unemployment. This is Mr. Casey's 15th bench warrant. He's had 9 prior contempt findings. For 10 months of compliance, Mr. Casey should have paid $750. He's paid nothing. Total arrears through the end of October are $4,506.24. Mr. Casey did book into the Calhoun County Jail on November 16th. And he was last sentenced to serve jail time on September 7th of 2022. He was sentenced to serve 90 days at that time.
Okay. Sir, do you dispute or contest any of the statements made by Ms. Brown?
No, sir, I do not.
Okay. Do you have any questions for Ms. Brown?
I do not, Your Honor.
Okay. What would you like to tell me, sir?
It sounds bad. It looks bad. Everything's true that, I haven't paid. But that doesn't involve me and my son's relationship. I got to watch him graduate Harper Creek High School this year. It's one of the best things I ever experienced in my whole life. And me and my sister were the only ones there. No other family, nobody, but me and my sister.
Okay. Well, that doesn't go to the issue of payment of child support. That's what we're looking at today. So
yeah, I understand. You just asked if I want to say something. That's all I got to say.
Okay. Sir, when was the last time you worked?
Back when the income withholding was for unemployment.
Okay, that doesn't tell me anything. It tells me
my last job was on record for Infinity. And that was some years ago. I've been trying to get with the Social Security Administration and get my disability in order. I signed up 2014 for it, which I was denied, and I've recently filed papers.
Okay, so you're previously denied.
Yep.
And what makes you think that you're going to get it now when you were previously denied?
I have been diagnosed with severe depression, so that's a different. That's different from the last time I filed.
Tell me at this point, what have you done in the last year to acquire employment?
I've tried to work with my previous employer, Southwest Michigan Fence. Not really much, sir.
Okay.
Just working on my depression.
Well, probably would help is if you acquired employment, that would probably help with your depression. Get you
yes,
out.
Sir.
What's your education background, sir?
I've graduated the 11th grade.
Okay. Did you do any GED or complete anything that way?
I've tried when I've done my 90 days in here, but it's never been long enough, but I've never tested, on the outside.
Okay.
Kind of always been too, I don't know, insecure to do it.
Well, it'd probably help you. And again, if you did some of these things that would be of success to you, then you wouldn't be insecure and you wouldn't be depressed. So, which sounds like you're going to need to do something to, again, get out of.
Is there any programs that the courts are working with? I remember back in the day, there used to be like Work First and stuff like that. I'm compatible to comply with any like Work First or anything that I could get better in the community with.
Okay. Ms. Brown, would he qualify for LEAP?
He would.
Okay. Sir, if I would at some point order you in that LEAP program, then you'll need to comply with it and you'll need to successfully complete it. You know that?
Well, that's all new to me. I don't know nothing about the LEAP program.
Well, it's a program whereby they work with you to see what your skills are, to help you with resumes, help you with filling out applications, doing anything
that sounds awesome.
Help you to get employment.
Yeah, that sounds like something I'm interested in.
Okay.
Just so we can stop coming to, just so I can, it's not that I don't want to pay it. It's just, I'm just caught up.
Yep. Okay. Well, in this matter, the court will make the following finding. Mr. Casey, is there anything else that you want to say before that?
No, sir, Your Honor.
Okay, thank you. Court has heard the testimony that Mr. Casey has basically had multiple prior cases. He had 9 prior contempt findings in this matter. He has a minimal support obligation. He's arrears only. He only has required to pay $78.50 per month. So that's a nominal amount that he hasn't complied, hasn't paid for a considerable period of time, and has an arrearage in this matter of just over $4,500, notwithstanding the nominal support obligation. He states as his reasons that he has depression, although he did apply many years ago through Social Security for disability. He did not receive that. That he has a 11th grade education. He has only tried to get his GED when he's been incarcerated and not done anything when he's been out. As he states, when he's asked in the last year what he's done to acquire employment, he says not much. As a result, the court will, in fact, find that he has failed to exercise due diligence, failed to refuse to comply, and he is in contempt of court. Anything before sentencing, sir?
No, sir, Your Honor. Just I'm excited to get with that LEAP program.
Okay. Well, what the court's going to do in this matter, sir, is based upon your history and again the non-compliance. What the court is going to do is I am going to sentence you to the full 90 days. I'm going to make you serve 60 days with credit for 13 days. I'm going to suspend the remaining 30 days and order you into the LEAP program. And so, I mean, I just don't think there's much value to keeping you in for the full 90. Want to get you out and get you into a program, and hopefully that will assist. But obviously, I think it's somewhat warranted. So the court will suspend the final 30 days, and the court would allow you to purge yourself of contempt by paying the sum of $500 in this matter. So any questions, sir?
So I got to pay $500 to get out of jail?
Yeah, yep. If you pay $500, you get out of jail, or otherwise you'll have to serve the remaining time.
How much is that?
Well, it's the 60 days less your 13, so you've got 47 days to serve.
Okay.
And then you have to participate in the leap. You're going to have to do that regardless. If you don't
Yeah.
participate in the leap, the court will put you back in for the other time. You
I
understand?
understand. No, I understand. I'm prepared for the relief program.
Okay. Okay. You're free to go. Thank you, sir. Thank you, Ms. Brown.
Thank you, Your Honor. Just, I want to make sure I'm clear in preparing the order. So he was actually sentenced to 90 days with 13 days credit, $500 purge. However, he had 30 days of the 90-day sentence suspended, and he's ordered it to leap upon his
Mr.
release.
Byrd, in this matter, you're currently charged with
Thank
civil
you.
contempt of court due to your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charge?
Yes.
Court would advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes.
Are you doing so freely and voluntarily?
I'm doing so today because my ex-wife is in the hospital and in serious condition, and she is supposed to be present today to relinquish the almost $10,000 that I'm behind with her, and I'm not sure if she'll be able to make it any other day. So
okay. Well, so are you doing so freely and voluntarily regardless of that information? You have a right to an attorney, sir. All I'm saying is if you're relinquishing, I'm trying to understand if you're doing it freely and voluntarily.
Yes.
Okay. Has anyone threatened you, coerced you, used any undue influence, pressure, or promises to get you to appear without an attorney?
No.
Okay. Thank you. Court will find that Mr. Byrd does freely and voluntarily waive his right to an attorney. Ms. Palatic, in view of what Mr. Byrd said, is there other arrearage owed or just that's owed to the pay?
There are two dockets. I believe the one he's talking about is with Tiffany Waltz. And there are arrears outside of what's owed to just Tiffany on that case. Okay. Both of these matters were here for an adjourned show cause before your honor. These were adjourned from referee Snyder for further enforcement. On the 1985 matter with Tiffany, current obligation is $307.50 each month. This is the second show cause. He's had one prior bench warrant and no findings of contempt on this matter. Compliance was measured over 1 month since the adjournment from referee Snyder. During that time, he's paid $22.94. There was also a $400 payment made yesterday that hasn't dispersed between the two cases. I'm not sure how much will go to each case yet because it's still pending. Current arrearage on this docket is $10,044.15 through the month of October. On the other docket, the 01 case with Miss Millard, current obligation is $453.50 each month. This is the second show cause with one prior bench warrant and no findings of contempt. Again, compliance was measured for 1 month. During that time, he paid $27.06. Some of the $400 will also apply to this case once it is dispersed. Current arrearage on this docket is $24,252.87 through the month of October. Mr. Byrd does report that he's self-employed still. He is actively participating in the LEAP program, but he's not complying with his payments on his own to meet the obligation in both dockets.
Okay. Mr. Byrd, do you go ahead, Miss?
I was just gonna say, I'm not sure if Miss Miller did come back, but she was planning on attending. She did want this hearing today.
Okay. Do we have anyone else on Mr. Flores?
We do not have anyone in our waiting room.
Okay, thank you. Mr. Byrd, you've heard Ms. Platic. Do you contest or dispute any of the statements she's made?
2 months ago, Judge Snyder ordered me to pay the full amount, $303.50 to Sequoia Millard, and I believe it was $257 to Tiffany Waltz, and I paid those, and then had another court date with him and ordered another payment of both amounts within 14 days, and I just simply did not have it. I couldn't make it, and that's why I paid the $400 yesterday. It was all I could come up with.
Okay. Again, any dispute with any of the facts as stated by Ms. Gladdick?
No.
Okay. Do you have any questions for Ms. Gladdick?
No, I do not.
Okay. What would you like to tell me, sir?
Um, I'm trying to be compliant. I just simply have not making enough money to survive. I'm the sole provider for my household. Also, I have my daughter, the case with Tiffany Waltz. I've had her in my full custody for the last 3 years and provide for her solely. And there has not been a custody change, and that is why my ex-wife Tiffany Waltz was supposed to appear today. She's gravely ill in the hospital with kidney failure and may not be able to make it to the next court date, but she was
Well, that's
trying
fine.
to be here today.
If we ignore the case involving Tiffany, then you still have a arrearage of over 24,000 on the other case.
Yes, sir.
So again, what do you do that you're self-employed?
I do construction, handyman service, jobs. I would like to mention something about the other case, and I had not been able to get it resolved, is in the case with Sequoia Millard. There has still been no paternity established ever. I have no visitation of the child in question. I've just been forced to pay for 6 years. And yes, that is racked up quite a substantial amount, but there is no paternity established and not on the birth certificate. So I don't know how to go about getting a paternity established.
Okay. Ms. Platic, we must have an order someplace. Can you check to see if we have a order affiliation in place or what?
Again.
Mr. Bird has stated that it was your intent to waive the arrearage of approximately $10,044.15, at least the extent of what's owed to you, not the service fees, et cetera. And he stated that he has full custody of your daughter. Is that accurate?
We have joint custody, but the child support, yes.
Okay. Okay. I don't want to, obviously, you understand you're in there for some pretty serious things, so I don't want to take up your time just to confirm that. You're free to go, ma'am. I appreciate you making the attempt to get on and letting us know.
Yeah, thank you.
Thank you. Have a good day.
You too.
Ms. Platty, you can get that issue taken care of, that she's waived whatever arrearage is owed to her. You can't waive whatever owed to the state, sir, or any service fees or anything of that nature. But hopefully with the monies that were paid yesterday, that could, in fact, clear up those issues. And then we would apply the balance to the other case with Ms. Millard.
Okay.
Sir, you work odd jobs, as you state, construction, et cetera. How much would you say you make in an average monthly income?
It fluctuates, but it's between $1,500 to $1,800 a month.
Okay. And obviously, based upon the arrearage and that the self-employment hasn't been going well, have you looked into any full-time employment?
I set up the stuff with the LEAP program. I filled out all the information. I attended that and filled out all the information they requested on that. I'm still employed with W4 Construction, and I subcontract for them. They're government jobs, construction jobs, and they send me all over the U.S. and just haven't sent anything my way in quite some time.
Okay. Again, it gets back to my question. What have you done to find full-time employment?
Just the LEAP program, sir.
Okay. I know you probably note as you go around town, and you probably hear employers have there's a labor shortage, and you can get employed almost anywhere. Use example, I know that Denso is hiring. They're hiring freely, which they hadn't done in the past. And you can get full-time employment there. They pay well, have good benefits. Have you looked into any of the companies out in the fort?
I have not. I previously worked for Denso. You guys were garnishing those checks for the child support. That was several years ago. So I don't know if I could apply for another job there. I may be able to, but some of the other factories I could as well.
Then if you could, why haven't you?
I'm trying to build my business, to be self-reliant, and I've been trying to focus on that.
Okay. How long have you been doing the self-employment?
3-4 years.
Yeah.
Alongside of W4 construction, which I was just in between. Because W4 is kind of an on-call type job.
Anything else that you'd like me to be aware of, sir?
No.
Okay. What the court's going to do in this matter, the court's heard the testimony, Mr. Byrd in this matter, as well as from Tiffany in the other case, we're going to take care of that issue. Mr. Byrd has participated in the LEAP program. It appears that based upon what he stated, that's about all he's done to acquire full-time employment. He is working in W4 construction, but that's subcontracting on a limited basis as needed. But he does do some self-employment in construction jobs where he makes between $1,500 and $1,800 a month. But again, as stated, he had previously worked at Denso. He didn't know if he could go back there. He also said he would qualify for other factory work out in the Fort Custer Industrial Park, but he hasn't done anything to acquire any employment. And as a result, the court will find in this matter, sir, that you have failed or refused to comply with the support orders in effect in this case. You have not made a good faith attempt at compliance and failed to comply, and therefore you are in contempt of court. Sir, what would you like to say anything before sentence?
I have been trying, which is why I paid when Judge Snyder ordered it, and I paid $400 yesterday. And I've asked to get a different judge at several points. Judge Kirkham, you were my divorce attorney in my case regarding Tiffany Wolf's. And as such, I feel it's a conflict of interest.
Yeah, you have a right. You have a right to file a motion. You can do that at any time. So that's what you're going to need to do if you want to have the court disqualified. Okay.
Okay.
Well, at the current time, you've not said anything to persuade me in this matter about your intentions to do anything in the future that you haven't done already. You haven't looked for full-time employment.
Absolutely.
So the court's going
to pick up more hours contracting.
Yeah. Well, at the current time, all the court can do is look at what's happening now, which is not payment. You got a arrearage in the one case of over $24,000. And so what the court is going to do, sir, in this matter, the court is, I could sentence you up to 45 days in jail. I'm not going to, but I do feel that some jail time is appropriate in this particular matter. As a first time, I'm going to sentence you to 14 days in jail, commencing December 8, 2023, that you report to the Sheriff's Department no later than 4:00 p.m. in this particular matter to serve your time. Or alternatively, what the court would do is I'm giving you that time so you can get matters in order, etc. That gives you about a week and a half. Or you can pay a sum of $1,000 to purge yourself of contempt. So if you don't purge yourself of contempt by that date, then you'll have to show up at the jail and turn yourself in. You understand that, sir?
Yes, sir.
You have any questions?
No, sir.
Okay.
I have a question, Judge.
Yeah, go ahead.
Are you sentencing him on both dockets or just the case with Millard?
Just the case with Millard.
Okay. On the case with Walt, are we dismissing?
Yes, we'll dismiss that and
have her forgive. Okay.
Yeah, well, once we get that arrearage forgiveness, that'll take care of that case.
Just want to make sure I get them both clear. Okay.
Okay. Thank you. You're free to go. Have a good day, and hopefully you can come up with the purge amount and you don't have to go to jail.
Where would I pay the purge amount?
You pay that through the front of the court's office.
Yes, sir. Thank you.
Okay, thank you.
Bye.
Judge, that is all I had for you today.